Chapter 44 Common Barratry, Maintenance and Champerty. Section 661 Common Barratry. Common barratry consists in frequently exciting and stirring up suits and quarrels either at law or otherwise. There must be a series of at least 3 distinct acts to constitute this offence. Moreover, the acts must be more than merely unsuccessful suits. If the suits are brought, however, merely to annoy the adversary, and are unfounded, the offence is committed. It has been held that a justice of the peace who stirs up criminal prosecutions for the purpose of obtaining fees is guilty of this crime. Section 662 Maintenance. Maintenance consists in the officious intermeddling in a suit by one who has no interest therein by maintaining or assisting either party with money or otherwise, to prosecute or defend it. Thus, it has been held that where a stranger to a suit induces the plaintiff to sue by promising to pay the costs in case he loses, the promisor is guilty of maintenance. As a rule, however, this offence is confined to cases where a man improperly, and for the purpose of stirring up litigation and strife, encourages others either to bring actions or to make defences which they have no right to make. In some jurisdictions this offence is not recognized at all, and in no jurisdiction is it held an offence for a man to maintain the suit of his near kinsman, servant or poor neighbor, out of charity and compassion. But the assistance must be because of the interest or relationship. Where several persons have a common interest in a suit brought by one of them, it is not maintenance for the others to contribute to the expense of the suit. Section 663 Champerty. Champerty, according to Blackstone, consists in an agreement to divide the land or other matter sued for between the parties if they prevail at law, whereupon the champerter is to carry on the party's suit at his own expense. It has been held, however, that it is not essential for the champerter to carry on the suit at his own expense, that champerty is committed by an attorney. For example, where he agrees to conduct the suit for a contingent compensation. This view, however, is very generally repudiated. In many states the courts have repudiated the common law doctrine relative to maintenance and champerty, and in many of them statutes have virtually repealed the common law pertaining to them. At the old common law both of these offences, as well as common barratry, were misdemeanors. Section 664 Modern Rule. According to the modern rule, the mere fact that an agreement between an attorney and his client provides for contingent compensation for the former's services, thereby giving the attorney an interest in the subject matter of the suit, does not render the contract void. But where the attorney agrees to conduct the litigation, pay the costs and expenses of the suit, or advance money therefor, in consideration of a portion of the sum or property to be recovered, the agreement is champertise, and void as against public policy. And where an attorney is so interested in the result of the suit as to pay the entire expense, control the settlement and take joint interest in the property, the contract will be void. An assignment of a claim to an attorney for a sum much less than he considers the claim worth, is champertise and void. The gist of champerty, according to a recent decision, is the malicious or officious intermeddling in a suit in which the intermeddler has no interest. This, however, is the gist of maintenance rather than the gist of champerty, where the facts justify it. The defense of champerty is tenable whether pleaded or not.